Growing up, I read in books, heard people talk about, and saw in movies where children went to court when their parents were getting divorced, and they got to tell the court what parent or parents they wanted to live with. I have yet to see that happen in the Utah court system. In my 7 weeks of being a legal assistant to this point, I have been to proceedings where custody and parent time were involved. When I began this job, I assumed that we would hear from the children in court. However, that is not the case. To put it bluntly in my own words, Utah courts believe that children should not be subject to the ugliness of their parents' divorce proceedings. From what I've seen, they are not allowed to be in the courtroom. They are prevented from participating in or even watching or listening to court proceedings that involve them. And the parents are strongly advised, sometimes even ordered, to not discuss the matters of the case with their children. I feel like divorce cases impact the children more than anyone else in the divorce process. Yet, they are the people who are shut out of meaningful contribution to the cases and proceedings the most. More often than not, the courts, or at least one of the attorneys, wants to appoint a guardian ad litem for the child. What is a guardian ad litem? According to the Utah Office of Guardian Ad Litem webpage on the Utah Court's website, it says, in court cases where families are in crisis and where children are being mistreated or are not receiving proper care, there is no one with more at stake than the child. A guardian ad litem ensures that the children's rights are protected, the child's voice is heard, and the child's best interests are advanced. So a guardian ad litem, GAL for short, is supposed to be the attorney who represents the child and protects the child's interest. How does a guardian ad litem do that? Well, from what I can tell, poorly. Basically, the children talk to the guardian ad litem, and then the guardian ad litem talks to the court, but does not tell the court what the child said. Instead, the guardian ad litem makes recommendations to the court as to what the court should do for the child, and does so ostensibly on the basis of what the child said, even though no one has any idea what the child has said, or if the child said anything at all. It is a state-sponsored bad game of telephone. I am no lawyer, and I'm not even that familiar with the legal system yet, but it doesn't take a seasoned pro to see that the guardian ad litem system isn't effective. How could it be the way to set up like that? You might be thinking, oh, okay, so guardian ad litems might be helpful for younger kids who can't express themselves very well in court-like settings, and there might be some merit to that argument, but courts will appoint guardian ad litems for children who are 14 years and up. Come on, these kids can speak for themselves. My takeaway from this is let the children speak. They already know their parents are going through a divorce. Appointing a guardian ad litem to speak for them doesn't shield the kids from anything but competent, attentive, and fair treatment by the courts. Kids in these situations should not be kept in the dark. They are the ones who are affected most by the court's decision. Their observations, experiences, feelings, opinions, and desires matter. They shouldn't be silenced or muzzled.